Hi, my name is Jeremy Larson. I'm a realty specialist at the Bureau of Indian Affairs Great Lakes Agency. Today I'm going to be talking about the process and what is needed for an application for a rights-of-way over Indian land, could be tribal land or individual Indian-owned land. I've been with the Bureau for about 4 years now. I am a member of the Kudurai Band in Wisconsin, and I have a wife and 4 kids. So today I'll be talking about the 25 CFR Part 169 for rights-of-way over Indian land. Depending on the project and the location of a project, BIA may transfer your application to the correct Bureau of Indian Affairs office with jurisdiction. This does not always happen, but it may happen depending on where you're located. So with me at the Great Lakes Agency, we're in charge of 11 tribes within Wisconsin. There's the Minnesota agency, there's the Michigan agency, as well as the regional office, which is in Minneapolis, Bloomington. Subpart A, land, applies to Indian and Bureau of Indian Affairs BIA land. So this land could also be tribal fee, which is land owned by the tribe in fee. There could be individual land, which would be allotments, as we call them. And then there's also Bureau of Indian Affairs land, which is also in trust. We mainly deal with trust land for the Bureau of Indian Affairs. And if there is fee involved or the right-of-way goes through a fee parcel, we do not accept compensation for the fee owners. We will not condition a grant of easement on fee owner consent, and we will not include the fee interest in a tract when calculating consent interests. The applicant is responsible for negotiating directly to the owners of any fee interest that may exist in the property which the right-of-way will be granted. When is a right-of-way needed? You need an approved right-of-way before crossing Indian land. So if you are a person or legal entity, including but not limited to an Indian, non-Indian, or a non-owner, or a federal, state, local government entity, or a third-party entity, which would be a service provider, such as, Xcel Energy, CenturyLink, just another utility that is looking for access to land or needs the right-of-way through that tract or parcel of land. If a fractional co-owner is an individual who has an interest in the land but is still required to obtain consent from majority of his or her co-owners unless 100% of the owners give permission to cross without a right-of-way. A right-of-way can be a railroad, public road, access road, service road, water line, sewer line, utility, so fiber optic, electric, transmission line, oil and gas pipelines, or distribution systems, or conservation easements. All those examples would be a right-of-way that we would need if you are crossing said land. The application. When it comes to the application for a right-of-way, we would like the request to come in to us, either be a submit and request, an email request to the correct Bureau of Indian Affairs office. That request will start the process, because if you, the applicant, don't know the Bureau of Indian Affairs tract number, that's why you have to get a hold of us, because in that way we're able to provide the information that you need for the application. Meaning, and we'll kind of go through that. And once you get that information, it's the applicant's responsibility to notify, to obtain consent for the survey, appraisal, environmental requirements within the application and the process for right-of-way. The slide you can see right now, this is a sample of our application. You'll notice that the application will identify the applicant's name, address, email, phone number, and then number 2, you'll see that it states tract or parcels affected by the right-of-way. This is why we ask you to contact us to obtain that information. Otherwise, you will not have it. Because when we request the land description review for the project, the survey will have to have the Bureau of Indian Affairs tract number on it, not the county PID or identification number that the county websites have. The application should also show the location of the right-of-way, which we call the map of definite location or survey. The purpose of the right-of-way, along with the duration, which would be the term. And if, as you can see on this one, it shows perpetual. There are, with the new regulations in place, there are really no more perpetual easements, and depending on the tribe's authority in that. We take into consideration if the tribe does want a perpetual easement, but for the most part, it's usually 25 to 50 years, option with renewal, possibly, and goes into that. The ownership of permanent improvements will need to be in place if it's going to be on the tribe or the applicant, who's going to be operating, maintaining, and managing those improvements. We will also need, excuse me, we'll also need the current environmental and archaeological reports. This is a process that there could be possibly someone from the tribe that will help with that. On our end, with the Bureau of Indian Affairs, we also look to our Natural Resource Department to provide concurrence that there's no effect in their environmental, depending on if it's a cultural burial site or if there's other things involved in that said location of where the right-of-way will be. You'll also see that we require a statement from the appropriate tribal authority that the proposed right-of-way is in conformance with applicable tribal law. All of these things will need to be stated within the application package. So with all of that, that's why we also have you try to contact the tribe when you know of a project that's going to be coming up or is going to traverse land that is Bureau of Indian Affairs tribal or individual. It also would behoove the applicant, if they know that a project's going to be happening either in a year or 2 years, to start contacting us and start the information, because the process can be quite lengthy. There are other offices involved with the right-of-way process. There's the Bureau of Indian Affairs, there's the Natural Resource Department with environmental, there's the Bureau of Land Management with concurring to the land description review. If there's evaluation involved, then we get the Appraisal Evaluation Services Office involved to review the appraisal for the tribe or the individual Indians, depending on what kind of project it is. So if you know of a project that's going to be happening, please contact us. Start asking the questions. If you don't understand it, look into the federal regulation. Anything that you have a question on, get a hold of us to explain it and also kind of let you know how it's going to happen. It's very hard to determine, how long the right-of-way process will take on each application. Each one is different. If it's 100% tribal land, it can go pretty quickly, where if there's allotments involved or individually Indian-owned land involved, there could be multiple owners within, if it's going across one tract of land, there could be 100 owners. If it's going through multiple tracts of land, there could be up to, it could be varied. It could have, one tract could have 4 owners, another tract could have 500 owners. It all depends on what kind of right-of-way you're getting and how many tracts it's going to traverse. So just kind of, here's another slide that kind of goes along with everything I kind of just talked about, the applicant. And all of these things need to be included with the application package. Again, the legal description, the map of definite location, if there's going to be a bond, insurance, we require that because of possibly damage happening. If it's a brand new right-of-way, there could be digging involved, other things such as bringing in equipment that could, that would need to be replace the land because of a divot or whatever happens to the land itself. When we talk about consent, we are looking to get the consent from the majority of the interest owners within a tract. So if you're going, for instance, going through a tract of land that has one owner, we need the consent of that one owner before we can move forward. If the valuation is going to be waived, then we will also need a statement from the tribal authority if there's tribal interest involved, as well as the individual Indian owners if they're going to waive. If the applicant is a corporation, limited liability, or company, partnership, or joint venture, we will need the organizational documents stating that the representative has the authority to execute the application, that the right-of-way will be enforceable against the applicant, and that the legal entity is in good standing and authorized to conduct business in the jurisdiction where the land is located. Again, the environmental reports, a statement from the appropriate tribal authority, the bond, and this would be the estimated damages resulting from construction of any permanent improvements, the operation and maintenance charges for any land located within an irrigation project, and then the restoration of the premises to the condition at the start of the right-of-way, or reclamation to some other specified condition if agreed to by the landowners. The bond or other security must be deposited with us and made payable only to us and may not be modified without our approval, except for tribal land, in which case the bond or other security may be deposited with and made payable to the tribe. BIA may waive the bond or insurance requirement if the tribe determines that a waiver of bond, insurance, or alternative form of security is in its best interest. For allotted lands, which would be the tracts with multiple owners, if the landowners of majority interest request it and BIA determines in writing that a waiver is in the best interest, while concerning the purpose of the right-of-way and risk associated with the right-of-way, the grantee is a utility cooperative or tribal utility and provides a direct benefit to the Indian land. The bond exception. This is a new kind of regulation within our 169 regulations that the requirements of this section do not apply to federal, state, tribal, or local governments who are provided by law from providing a bond, insurance, or other security. If this is something that you are going to use, then you must provide it with the application, and then also provide notice to all the tribe and for tribal land, and then at least 60 days before canceling the bond, insurance, or other security. This will allow us to notify the grantee of its obligation to provide substitute bond, insurance, or other security before the cancellation date. If you're going to waive this requirement, we ask you to submit that with the application for the waiver, and that it's in the best interest statement as part of your recommendation memo. The map of definite location, or survey. The survey is a plat signed by a professional surveyor or engineer showing the location and size and extent of the right-of-way as it traverses the Bureau of Indian Affairs tracts or parcels of land and needs to be referenced in the survey that under 25 USC 176, 43 USC 2, and 7064, and showing existing facilities adjacent to the proposed project. So if your right-of-way is traversing, which I'll show kind of on the next slide that's coming up, that as it goes through the parcel, it could have buildings or structures. We'd also like to know that if the next tract involved in the location is also a Bureau of Indian Affairs tract. So it should have that Bureau of Indian Affairs number located somewhere on the survey. This is just other things that correlate to the map of definite location. Our Bureau of Land Management, who will concur to the survey, will want to see the true bearing and ground distances, the commencement ties from the PLS corner to the point of beginning, to tie the public land survey system corner form point of ending, describe monuments recovered, identification of the BIA tracts and acreage affected by the right-of-way, solid lines equal survey, dash lines equal tire computed. All these things need to be included in the map of definite location or the survey that correlates to the right-of-way project. So here is a survey or map of definite location that we kind of like to see. You can kind of see that they have, here's the section breakdown. Here it is also. You'll see it has the allotment number, and as it traverses through said parcel. Then it has the surveyor's affidavit along with the applicant certificate as well as the legal description. This survey was a concurred survey from the Bureau of Land Management for one of the projects that we've had. And as long as your survey looks somewhat like this or has all the information within what the last slide explained, it should be able to be concurred and will keep the project going. The survey is one of the most important pieces of the right-of-way process. It kind of starts everything on my end. So meaning it's once I have the survey and it's concurred, I can, if there's a valuation, provide it to the Appraisal Valuation Services Office or AVSO, as well as provide it to our Natural Resource Department to start the environmental. I cannot start those things without the survey. The survey is what they go to look to make sure that everything correlates to said right-of-way project. Consent. How to obtain consent for a right-of-way. So the applicant obtains the consent. The applicant must submit a written request to us. That's why we ask you, when you know you're going to start the right-of-way process, contact us, send a letter, let us know where you're going so we can provide you names and addresses if there's allotments involved, the ownership interest as well as the parcel information, which would be the BIA tract number. Allotted land, the applicant needs to show that it has notified all owners of each tract and has obtained majority consent of each tract. So majority consent consists of the greater number, so anything over 50%. So 51% would be your majority consent. The Bureau of Indian Affairs may grant a right-of-way without individual landowners' consent if all of these apply. If you have just two of the bulleted items, it doesn't work. All of these things have to have all of these, or we will not be able to consent to it on behalf of the landowners. The owners are so numerous, it's impractical to obtain consent. If 50 or more co-owners of an undivided trust or restricted interests, there's no substantial injury to the land or any landowner. All landowners will be adequately compensated. And then Bureau of Indian Affairs provides 60-day notice of intent to consent on behalf of all owners and provide 30 days to object. How do we determine fair market value for a right-of-way? We use the market analysis appraisal or other appropriate valuation method to determine the fair market value before we grant a right-of-way over or across individually owned Indian land or tribal land. If the fair market value of tribal land, we will either prepare or have prepared a market analysis appraisal or other appropriate valuation method, or will approve use of market analysis appraisal or other appropriate valuation method from Indian landowners or the grantee. We will use or approve use of market analysis appraisal or other appropriate valuation method only if it has been prepared in accordance with USPAP or valuation method developed by the Secretary under 25 USC 2214. And it also complies with the third-party appraisals or has been prepared by another federal agency. When are monetary compensation payments due under for a right-of-way? The compensation for a right-of-way may be a one-time lump sum payment or may be paid in increments, for example, annually. If the compensation is a one lump sum payment, the grantee must make that payment by the date we grant the right-of-way, unless stated otherwise in the grant. So if you negotiate with the tribe on a different date other than the date that the grant is approved, then that would be included within the grant. Each right-of-way is different. It all depends on, what you've negotiated with the tribe or with the individual Indian landowners. Usually for a right-of-way, it's a one lump sum payment that's made and goes into what we call the lockbox. And then the Office of Special Trustee gets involved with that, with the individual Indian landowners and or the tribe. And that's a process on our end. But of course, we keep the applicant up to date on all that information. Again, increments may not be more frequent than quarterly if payments are made to us on the Indian landowner's behalf. Piggybacking. This is with the new regulations, there is what we call no longer piggybacking, but there are some instances where it can still be utilized. If, for instance, the use is not specified or not the same scope as in the original right-of-way grant, and the new user will not require any ground disturbance, then you may want to obtain an amendment to that original grant. If there's new use with new ground disturbance, you will need a new right-of-way. If the new user is the same scope, such as fiber optic, then that request from the grantee for an assignment for the new user of the original right-of-way allows an assignment. So if the language of the original grant does not specify an assignment, then you'll need to obtain a new right-of-way. If you're a new user and different scope, then you'll have to apply for a new right-of-way. So basically, if you have an existing right-of-way and the original grant specifies certain language within it, it's possible you can still use that same right-of-way. For the most part, I've seen that it's easier just to obtain a new right-of-way because either, it's going to become expired or, depending on what's going on. We're finding a lot that with this new regulation, we're finding more of the right-of-ways that we did not know about. And that's kind of where this is taking place and kind of helping the tribal entities, showing that there's something there, but we have no record of it. So it's keeping our records and also the applicant's records to show that Either you do have a right-of-way or you don't, and this is what we have to do to obtain a new right-of-way. Effectiveness. When will the right-of-way be effective? A right-of-way will be effective on the date approved unless otherwise negotiated by the tribe and the applicant. So when the superintendent or regional director signs that right-of-way grant, that is the day the right-of-way is effective. Once it is signed, the Bureau of Indian Affairs will then record the right-of-way with the Land Titles and Records Office. And once it is recorded, we do provide a copy to the applicant, the tribe, or the individual Indian landowners to hold for their records, to show that there is a right-of-way traversing either the land they owned, and to have that in case anything happens in the future. Service line agreements. This is a new regulation within, well, it's not new, but within the new regulations, a service line is mainly a utility line running from a main line, transmission line, or distribution line used for supplying telephone, water, electric, gas, internet service, or other utility service to one house or business or structure. So if you need a right-of-way and you know you already have a right-of-way, you could possibly use a service line agreement to run off that main line. But it can only service one building or structure. If you're going to service two structures, you're going to need two service line agreements. We never used to record service line agreements. With the new regulations from 2016, now in 25 CFR, we do record them. It is an extra information for us to show, and also show the tribe or individual landowners what is located on their land, to help with, if there's going to be a lease or if there's going to be a new building or whatever it may be. A service line is there to help provide that information. Within the service line agreement, it's signed by the utility provider as well as either the lessee or the tribe. It'll show, where the access is, where it's going to. If it's power lines, the voltage has to be 14.5 kilovolts or less, or a voltage of 34.5 kilovolts or less for serving irrigation pumps and commercial or industrial uses. Anything higher than that voltage will require a right-of-way. Service line agreements to multiple units would require a right-of-way also. So if you're doing a housing building, you can't just do a service line. It's more likely going to be a right-of-way. Here is an example of a service line agreement. You'll see that, we'll want to know the service provider or the applicant, as well as the purpose, the legal entity or authorized occupant. If it's going to be, if it's a tribal member who's leasing land from the tribe, we'll want to know where it's located. So the section, township, range, county, state. We'd also like to know the acreage. So if you see on the example here, here's 100 feet, here's 75 feet, and here's the well. This one's using, a well. I'd like to know how many feet this is and how many acres that service line is going to take up. We'd also like to know the purpose of why you're supplying the service to the premises. And you'll see that we like the applicant name or signature, the authorized occupant, and the lease number if there's a lease involved, the name of the tribe, and then Bureau of Indian Affairs fills out this part where, it's filed with the superintendent or agency or other officer in charge on this date. So if a service line is on a second page and not on that first page as I showed earlier, all parties will need to sign the service line diagram or exhibit. If it is not signed, I will be sending it back to you to re-sign, because per the regulation, if the service line is on a second page, the service line also has to diagram has to be signed. Just because you sign this page, which is the second page, does not count. We also would like you to have it signed here. So if you can get it on this first page, it'd be great. I wouldn't have to be sent it back because it's within our regulation that it is good. Filing and recording. So when the service line is executed and comes into the office, I have 30 days after that service line was signed to get it recorded. So again, with just like the right-of-way, the service line will be recorded with the Land Titles and Records Office, and once it is recorded, I will send out a copy to the tribal entity as well as the applicant and or the lessee to keep for your records and to show that you do have an actual service line for that location. Any questions? Here's all my information, my email address, my phone number. Of course, currently we are, teleworking within the Bureau of Indian Affairs because of the pandemic that's going on right now. But I do check my email regularly, and I also still check my phone calls regularly. Leave a message, give me a call, send me an email if you have any questions on anything. We're here to help and give you guidance on the rights-of-way process, as well as other information that you may have with the realty department or land. That's including leases, rights-of-way, fee to trust acquisitions, trust to trust acquisitions, anything kind of dealing with land, we can hopefully be able to provide you assistance and give you answers. Thank you.